Hello everyone. So finally we are starting our CPC lectures also. So I already have uploaded one introductory video that talks about what all things will be covered by this lecture. And today it's our first discussion that is on CPC. So today we will talk about what is CPC, some of the elements of CPC, what is the nature of CPC, and some of the facts related to CPC. है ना? So first of all, whenever I say CPC, I mean the Civil Procedure Code of 1908. So I will no more say Civil Procedure Code of 1908. Instead, I am always going to say CPC. With this disclaimer, let's begin. What is CPC? So firstly, CPC is an adjective law. What is an adjective law? So there are basically, there are different kinds of law. And if we want to divide, for example, we can divide the law into local law and special law. We can divide the law into criminal law and civil law. So on different kind of subject, we can divide law. Today we are going to discuss the distinction between substantive law and procedural law. So CPC is an adjective law, which means it is a procedural law. So adjective law, whether you say adjective law or procedural law, it means same thing. Now what is the difference? So substantive law means that in that law, some substantive provision, some principles, some definitions, some punishment has been given. Okay, it do talk about what is exact offense and what is the particular definition of this particular word, like this. So that is substantive law. And procedural law will never create a right. Okay, it will only talk about the procedure, how to implement your right, or how, if your right has been violated, what procedure will get you to the justice. So substantive law creates a right. Procedural law helps the substantive law to literally claim that right. So in procedural law, barring only few things, that is, if we talk about criminal procedure code. Criminal procedure code is also a procedural law, है ना? So general rule is it will not give you any kind of substantive right. But we do have certain kind of provisions, like all the provisions related to arrest. So when you will study arrest under CRPC, you will also read the rights of arrestee or the right of the person arrested. So barring few things, generally procedural law does not give you or does not create any kind of right. But substantive law, the sole purpose of substantive law is to give you some kind of right, is to define what is offense, what is crime, is to define punishment, what will be the punishment for a particular offense, for example, BNS. Okay, so for this, CPC is an adjective law, or you can say procedural law. So it will not give you any kind of right, but it will only facilitate you to get your right, what you have claimed. Okay? So, and if I just want to quote here Salient, that according to Salient, procedural law is that branch of law which organizes and regulates the proceeding in a dispute. है ना? तो देखो, for example, if we don't have procedural laws, then what will happen? Simply, then it will be like a toothless tiger. Our whole law system will become toothless tiger. That is, at one point, on one hand, you are talking about you have this right, you cannot commit this offense, you can be punished for this thing, you have you have fundamental right. Yes, obviously, even when you go to Supreme Court, that is also governed by procedural laws. है ना? So on one hand, you will have many laws which gives you many kind of rights, will prevent other person to not to commit something, will force some authorities to do something. So there will be good things on one hand, but on the other hand, there will be no procedure to how to implement it. है ना? So for example, if BNS is talking that it has given the provision of theft. If we talk about IPC, section number 378 of IPC. So it says that in what all circumstances, if all those conditions get fulfilled, it is said that the offense of theft has been committed. ठीक है. And then section 379, 380, 381, 382, all these following sections talk about what will be the punishment in different kinds of thefts. ठीक है. Now IPC has talked about what is theft. IPC has defined what is theft. IPC has also mentioned what will be the punishment to commit theft. Okay, now what? So substantive law has given you the definition of crime. Substantive law has given you the punishment also. Now what? How the victim will ensure that the accused person or the culprit will get the punishment. It is not possible to directly take the culprit and present before the court. Okay, so there is a full procedure in between, from the commission of the crime till the date of judgment or trial. So there is a procedure in between that talks how a justice can be given. ठीक है, justice ये है, it's fine, that is something which substantive law talks about, but how to deliver that justice is all about procedural law. ठीक है, so IPC will only say section 378, that is theft has been committed. Section 379, 380, 381, that is IPC will say that in this case this will be the punishment for theft. But for FIR, for registration of FIR, for the arrest of the accused person, for the cognizance part, which court will have the power to take cognizance, then for the trial part, then for the examination, re-examination, and also presentation of documents, witness, and all the things, another thing. Then how to pass a judgment, what should be there in judgment, what about sentence, and then decree, then execution of decree. All these things are nowhere in substantive law. All these things are in procedural law. What is the procedure in the court? ठीक है, so you will go to the court when your right has been violated. I am not here talking about any specific right, not talking about only fundamental right or statutory right or constitutional right, but right in general, that some cause of action has arisen, some right has been infringed, or something has happened against you, that is a substantive law matter. But what all things will how the court will function, how the advocate will present his case in front of the court, everything related to proceedings inside the court is given by the procedural laws. So in India, typically we have two procedural laws, that is criminal procedure code, or now I can say Bharatiya Nagrik Suraksha Sanhita, and the other one is Code of Civil Procedure. Today what we are talking about. So this is the difference between substantive and procedural law. The next one is, as it is very much clear that the CPC has been implemented in the year 1909. So almost all the acts have been amended at some point of time. So just a general fact that when IPC was got amended. So far the major amendments in IPC covers 3 amendments. The first amendment in 1976, which got implemented in the following year only. ठीक है? The second most important is in the year 1999, and the third amendment in CPC is of the year 2002. Now, one good thing to remember is this Amendment Act of 1976 was implemented the year after only. But these two acts, Amendment Act of 1999 and Amendment Act of 2002, both got implemented together, that is in the year 2002, July 1, 2002. So these two got implemented together July 1, 2002 and 1976 का हो गया था उसी के following year में. Fine. Next thing is, what is the object of this act? It becomes very simple to understand any act when you really understand what is the object of that act. So the object of CPC is to consolidate and amend laws relating to procedure of the courts in civil judicature. So it was not like that before 1908 there was no procedure of things that works in court. है ना? There were procedure. But the thing is, this act consolidated all the rules and regulations and laws which were here and there. So when the object of act is to consolidate, if you pay attention to the object of all the acts, you will get different terminologies. When we talk about CRPC and when we talk about CPC, the terminology which we find in its introduction is the object is to consolidate and amend law. है ना? So whenever we are talking about some code, है ना? So generally the purpose is to consolidate only. So it is like even before this act there were some kind of rules, regulation, different acts. So this act has consolidated everything and put together into one act. So this is consolidation. And obviously to amend laws relating to the procedure of the courts of civil judicature, not criminal judicature. We are talking about CPC. है ना? And then this code, other feature of this CPC is the code is not retrospective in nature. अब ये retrospective क्या होता है? See, in law we have this terminology which is frequently used whenever we talk about that implementation part or effectiveness. So retrospective means ये होता है that the law cannot be implemented backdated. That is, if I have implemented a law on this particular date, that is 29th of September 2005, then this law cannot deal with the matter which has happened before this particular date. So whatever has happened before 29th of September 2025, those things will be governed by the laws which were there earlier. But after this date, these matters will be regulated by this act only. So retrospective means such and such act cannot be made effective backdated. ठीक है? ये prospective ही होगा, अब से होगा, आगे से होगा. So the code is not retrospective in nature. Now another very unique feature of CPC, you will not find it anywhere. I like CPC because CPC is literally different from other acts. Okay, so the scheme of the code is very different. All the laws are very what to say, general, है ना? सब लोग एक ही पैटर्न फॉलो कर रहे हैं. Preliminary, objective, section, provision, end. ठीक है? This code has a different scheme in the sense that the code is divided into two parts. Part 1 or is this one part is about sections or provisions, and this part, the other part, is about order. है ना? Now you cannot say, see, in other what to say, laws also, acts also, we have seen that they have provision, section, and they have schedules, and maybe they have some other kind of details after, but we never go and read that schedule and all, है ना? Those are not that important. But this thing is totally different in CPC. Orders are as equally important as other section of CPC, है ना? The thing is, you cannot isolate the sections of CPC from order. So the study of CPC is a different in a way and difficult in a way, that is, in this subject you don't just have to remember the sections, but also along with those sections you have to be remember और orders and rules as well. ठीक है, तो ये थोड़ा different setup है. At the beginning we may find it difficult, but once we start to understand, we actually feel it, मतलब we flaunt it, that we have this much detail, that section 9 read with order 9 and rule 8 hypothetical situation. It doesn't make sense, okay, this order and rule whatever I have just did. So but when you know that this section read with this order, read with this rule, then it really gives you that feeling that you are an expert. ठीक है, anyways, so yes, so one more thing for orders and rules. See, even though orders are as equal important as other provisions, that is from section 1 to section 58 of CPC, but there is just one difference. The difference is the sections, that is part 1, the section from section 1 to section 158 can be amended only by parliament or state legislature. ठीक है, it cannot be easily amended or changed unless it is done by parliament, है ना. But if we talk about orders, from order 1 to order 51, we have 51 orders. So from order 1 to order 51, even the High Court of a particular state may amend, may modify the order. ठीक है, so this is the difference. The substantive part of CPC, that is from section 1 to section 158, cannot be easily amended, and it can only be amended by parliament or state legislature. But the orders from order 1 to order 51 can be modified, amended, changed or altered by the high courts of different state. So this is the difference in order and rule. With this, our introduction on CPC is over. From next lecture, we are going to discuss definitions, and also we will start sections like section 9, 10, 11, res judicata, res sub judice, and all these things, है ना. So that's all for today's lecture. See you in next lecture.